The Jackson County Appraisal District presents Protesting Your Property Value. The following video is provided to educate Jackson County property owners about what takes place during the protest phase of the appraisal calendar year. Information will be provided about property owners' right to protest, common reasons, and important dates. Informal meetings with appraisers, evidence typically presented, the Appraisal Review Board, and formal hearings in an effort to answer any questions property owners may have about the process. The protest phase begins once the first appraisal notices are mailed. Chapter 41 of the Texas Property Tax Code defines actions a property owner is entitled to protest. Reasons are listed on the State Comptroller's Notice of Protest form, and also the one attached to the appraisal notices sent by the Appraisal District. Property owners who decide to protest after receiving their appraisal notice from the district are required to indicate which reasons may apply, or add additional comments, sign, date, and file the protest before the deadline on the form. As illustrated, various reasons may be selected when filing a notice of protest form. The most common indicated for residential property are market and equity. Value is over market value is checked when a property owner feels the district's appraised value is excessive and the property would not sell on January 1st of that year for the amount determined by the appraisal district. Value is unequal compared with similar properties is used to indicate the property is not appraised at the same level as a representative sample of comparable properties appropriately adjusted for various factors. For additional explanations of reasons for protest options, contact Jackson County Appraisal District. The deadline to file indicated on the notice of protest form is very important. By law, property owners who wish to file a protest must do so before June 1st or within 30 days after a notice of appraised value is delivered. The deadline on the form reflects the last day the form may be mailed or hand-delivered to the appraisal district to qualify for a timely protest. The law also requires that prior to July 20th, the sum of appraised values of property still under protest must not exceed 5% of the total appraised value of all other taxable property. The chief appraiser is required to certify the appraisal roll by July 25th to the taxing units, such as the school districts, cities, and county, so they may begin setting rates and assessing taxes for property owners. To achieve these deadlines, employees of the Appraisal District and the Appraisal Review Board spend May through July meeting with property owners who have questions or concerns about their property or have filed timely protests. The majority of residential appraisal notices are mailed in April, and a typical protest deadline of June 1st provides the appraisal district the capability to utilize the month of May as an informal inquiry period to meet with property owners. At this time, appraisers are made available to explain the mass appraisal process, illustrate data used to establish value, consider information presented from property owners, and confirm or adjust values of property discussed. Also during this time, the property owner and appraiser may come to an agreement and conclude any further process, or the property owner may choose to file the notice of protest by the indicated deadline. The Appraisal Review Board will then mail notification of the date and time of a formal hearing. The property owner will then be required to attend a formal hearing with the Appraisal Review Board at that scheduled day and time. The Appraisal Review Board does require that the property owner meets with an appraiser for an informal hearing before the scheduled formal Appraisal Review Board hearing. Examples of common evidence property owners are encouraged to bring to informal meetings and formal hearings are sales documents of the subject property, sales prices of similar properties in the same area as the subject, construction cost documents, repair estimates, appraisals and photos. Sales information normally considered has occurred from January of the prior year through March of the current year. If market value is protested, the district appraiser will research the database for sales information in the market area of the subject property. Then, sold properties that are most comparable to the subject property are selected. Size, age, and quality are typical factors considered. Once comparable sales are selected, an analysis is prepared that determines if the noticed market value of a property is within acceptable parameters of appraisal standards or requires a value adjustment. If equity is protested, an analysis following the guidelines of Texas Property Tax Code 41.43b3 is applied. Comparable properties to the subject are selected. Next, they are appropriately adjusted for the differences to determine if the property is equitably appraised or requires a value adjustment. Following the examination of all evidence, the district appraiser will indicate whether the market value or equity is appropriate or requires adjustment. The Appraisal Review Board, or ARB, is the administrative review arm of the property tax system. It is a separate and independent quasi-judicial entity with responsibility to conduct formal hearings between property owners and appraisal districts. The ARB only has authority over protests submitted to it. The ARB has no role in the day-to-day operations of the appraisal office or in appraising property. Property owners wanting to present protest information to the ARB will proceed from the informal meeting with an appraiser to the formal hearing. A district appraiser is responsible for presenting the evidence discussed in the informal meeting. The law requires that prior to a hearing, both district appraiser and property owner must sign affidavits swearing to tell the truth, and that information about the property has not been previously discussed with any member of the ARB. The hearing is administered by the ARB panel chairman, and he or she begins by explaining the rules of the proceedings. Property owners have the opportunity to present evidence first, followed by the district. Members of the ARB may ask questions of either party. The appraisal district is required to prove that values are correct at the hearings by a preponderance of evidence. If the appraisal district fails to meet the burden of proof, the ARB must decide the protest in the property owner's favor. Any member of the ARB can then offer a motion indicating what action to take in response to the evidence considered. If a motion is seconded, an oral vote is taken. A majority vote is required to pass the motion and conclude the hearing. A letter containing the decision, final value determination, and further rights of appeal will be mailed to the address of record. We appreciate your interest in the presentation explaining the protest phase of the appraisal calendar and hope the information presented offers a better understanding of the following important topics. Who can protest? Common reasons, important dates, informal meetings, evidence presented, the Appraisal Review Board, and formal hearings. Thank you.